another obsessive troll who actually got the transcript from court.
Description. I'm now going to read to you key parts of the transcript. These are the words of Judge Dean in her sentencing of Curtis Arnold. You now fall to be sentenced for 12 counts of fraud relating to 12 separate victims, 1 count of voyeurism and causing a person to engage in sexual activity relating to a 13th victim, and 1 count of making indecent images relating to a 14th victim who was 17 at the time. In relation to the 12 frauds, those offences started in March 2015, but went on for nearly 3 years until your arrest in April 2018. The pattern was that you would get to know women who were training at a gym. Sometimes, these were gyms which you knew full well you were banned from using. You pretended you had a company. You pretended you had a business partner called Sarah or Laura. You would ask the young women to model clothes for modelling or research purposes, offering them payment or free clothes in return. The clothing was deliberately tight-fitting. You took photographs, and there were occasions which you posted those photographs up onto your social media account without their knowledge, something I consider a particularly aggravating feature of this case. The women were of course lied to because they never got the payment of the clothes, and they were left feeling embarrassed and some of them humiliated. You sometimes met these women late at night when there were few people around in the gym, and I've looked at some of the text messages in this case which show not only are you a determined liar, but at times there would be a degree of unpleasantness close to bullying. You approached HC by Facebook in March 2015 telling her, as you were, that you were a powerlifter, telling her that you made videos for a friend's company and asked her to model prototype leggings. You then met her at a gym in the Royal Holloway. You had your 10 to 20 pairs of leggings with you. You asked her to put a pair on and bench press, and you filmed her in a way that made her feel uncomfortable. You also asked her to try on several other pairs of leggings, which she saw were old and worn and sweaty, and indeed one pair had been altered at the front so that it showed her pubic area. Of course, she foolishly agreed to wear several other pairs but felt very uncomfortable, and then had the humiliation of realising that you had uploaded footage of her onto YouTube. And so it was that she was your victim. Your next victim was in April 2015. She used to go to the gym where you mainly trained. She did not like the way you looked at her, but you came over telling her you were a powerlifter and offered her assistance, and then later asked if she would be interested in doing some videos for a legging company, pretending that you worked with someone called Sarah. And then on the 10th of April 2015, provided her with low-cut leggings, filming her doing exercises. And of course, she too was to realise that this was all a lie, and she became aware of your YouTube account. And she set out the harm that you have caused her in her victim personal statement. And of course she says the obvious. Had I known that your purpose was for your own sexual gratification, I would never have consented to you watching or filming me at all. I now feel scared because you have intimate images of me. I'm concerned about what you might do with them. That May, you defrauded DC, offering her money to model leggings and making a pose, asking her to pull her buttocks apart. The same month you defrauded Ms M at another gym in Fulham. She felt very uncomfortable throughout the whole process. In February 2017, again in Fulham, you approached Ms C with a lie about having a prototype, and the light-fitting reflecting material meant she would not have to wear any underwear. And you made her squat and stretch in these leggings to the point that her pubic hair could be seen. And of course she was lied to, and of course there was no payment for her. In August 2017, in February 2017, again in Fulham, you approached Ms C with a lie about having a prototype, and the light-fitting reflecting material meant she would not have to wear any underwear. And you made her squat and stretch in these leggings to the point that her pubic hair could be seen. And of course she was lied to, and of course there was no payment for her. In August 2017, you defrauded LS, and you got her to agree to be filmed in her own clothing at work. She believed this was for research purposes. That November, you defrauded HM, again getting her to pose in leggings, asking her to give herself a wedgie. And she noted that a pair you asked her to wear did not have any crotch, and that her underwear would be fully on view. And she was left feeling so embarrassed by the whole thing. Moving on to count 19, in late 2017 you approached SS. You pretended you had your friend called Sarah, and that you had a proper purpose for taking their photographs, which you did not. And she stopped agreeing to be photographed when she realised that you wanted her to be in rather lewd poses. In January 2018, you defrauded JJ, again lying to her that you were doing research work, getting her to put on a pair of leggings that was so low she felt almost naked. In February 2018, you defrauded EM at a different gym, again pretending that this was for research purposes. And in this incident, a very unpleasant feature is that you asked her to go into the toilet with you to have further underwear photographs taken, telling her that most personal trainers do this in order to obtain measurements. Thankfully, she refused, but she described how when she became pretty angry with you, you were not at all pleasant back to her. In March 2018, you defrauded an old school friend, KC, and you approached her under your fake partner's name of Laura, and told her all sorts of lies about this Laura, and the facts of that are set out in the opening note. And then in April 2018, in the evening at a gym that you had been banned from using, you defrauded SH, again pretending you had this business, getting her to meet you quite late, taking photographs of her, getting her to put her pants up and carry out the wedgie test that she all found rather strange, and made her feel rather uncomfortable. And she of course in due course reported what had gone on to the gym staff. So those in an outline deal with the frauds. SE, as you well knew, was underage. You well knew because you had been part of her induction to the gym. She was 17 years old when you took photographs of her. She described being led to a private training area at the back of the gym, asked to try on different pairs of leggings, asked to walk on a treadmill so that photographs could be taken from behind. And then of course the voyeurism and causing a person to engage in sexual activity without consent went on in March 2018 when you approached Ms B by Instagram, offering her money to model leggings. You were pretending to be Laura. There was in due course a meeting. She was asked to wear a dress that rode up to reveal her buttocks, and she was asked to be on the treadmill. She was asked to jump about in an unsupported sports bra based on a lie. She was asked to model leggings which were thin and see-through and invited to conduct the wedgie test. And of course, she was invited to massage her bottom with a toy. It never penetrated. She was asked to jump about in an unsupported sports bra based on a lie. She was asked to model leggings which were thin and see-through and invited to conduct the wedgie test. And of course, she was invited to massage her bottom with a toy. It never penetrated, but that was what she agreed to do and was filmed doing. And of course, she was asked to lie on the changing room floor with a thong on her back with her legs spread. And she consented to this because she believed she was assisting you with your research. And of course, she never got the money, and indeed was told that there would be no money unless she met you again. Now, of course, back in 2016, the police spoke to you because they had reports. About your activities. You complained that there was a Facebook campaign against you, which there was, but it is of great concern that the police gave you some very strong advice about your future behaviour, which you completely ignored. And then in April 2018, when you were finally arrested and interviewed under caution, you gave an extremely detailed and elaborate story. Indeed, it was an extremely bold lie. Now you are 30 years old, you have a large number of previous convictions. I recognise that there was a gap of 5 years before your last offences, and these, that may be inaccurate. I've taken that from the pre-sentence report. Looking at your antecedents, 18 convictions for 31 offences. Your last court appearance before these offences, September 2013, so in fact just about 2 years or even less before your offences. Offences for violence, for dishonesty, for arson, and for perverting the course of justice. The author of the pre-sentence report, of course, highlights that the offences back in 2007 and 2009 demonstrate a misogynistic attitude to women. The perverting the course of conduct relates to quite determined lies about who have been driving. And the arson, which is always a troubling conviction, I am told relates to setting fire to curtains in a restaurant when you were high on ecstasy. So it seems to me that your previous convictions are an aggravating feature of the case, although of course I recognise that they were not for sexual offences. I have to sentence you of course in consultation, or rather by following the definitive guidelines. And I turn first of all to the fraud guidelines. Everyone agreeing that they do not easily fit into the guidelines because of the sexual element to this case, but in terms of high culpability, which is not contested, this was plainly an elaborate deception. It went on for over 3 years. You made up a business partner, you made up fake media profiles, you attended gyms which you were banned from attending, you misled the victims about your status at those gyms. On your own account in the pre-sentence report, there was a strong sexual element behind your offending. Many of these offences took place after the police had given you advice. And of course, in terms of the harm, there was some financial loss to the complainants, in the sense they never got paid or they never got clothing. But the harm here really was that at the time many of these young women felt that you were weird. Later on they felt exploited and humiliated. And of course, as they, young women, get older, they're going to feel more and more foolish about what was going on. And of course, a real aggravating feature I've already referred to is the fact that some of these images were put up on social media without their consent, which is extremely alarming for the women concerned. In terms of remorse, you'll have to understand that I hesitate in accepting that you are genuinely remorseful. The reason for my hesitation is that these offences went on for a very long time, they were very manipulative, and you spun a very elaborate lie in interview. The judge then went on to decide the sentence. Amongst other remarks at this point, the judge observed that Curtis Arnold had effectively humiliated a 17-year-old girl, a girl you knew to be 17. I just thought I would reiterate that point. The judge then said that the total sentence that he would serve is a sentence of 40 months imprisonment. She then made a sexual harm prevention order, saying, "It is plain, given these offences, that a sexual harm prevention order is necessary and appropriate, and I make such an order. Now, Mr. Arnold, it is very important that you comply with the sexual harm prevention order. The length of the order will be commensurate with the length that you are on the sexual offences register. So what you are prevented from doing is possessing any device, including cloud or similar remote storage media capable of storing digital images, moving or still, unless you provide access to such storage on request for inspection by a police officer or police staff employee. And you are not to install any encryption or wiping software on any device other than that which is intrinsic to the operation of the device." Those were the terms of the order, and it was for a period of 10 years, which means the sexual harm prevention order expires in 2029.
And what the basis of the story that I've heard other people talking about is that I've defrauded women in gyms to have modelling photos taken and then basically not paid them, and I've read that I've posted them on social media or a website to sell the gym products, my own gym products. So my first question to counter that would be, if these photos or these images and videos of said people are of a nature which would make me, if these images or videos are of a provocative nature of too much, or worse, they're indecent, let's say, right? That word gets used, yeah? So people need to think about that.
In February 2017, again in Fulham, you approached Miss C with a lie about having a prototype, and the light-fitting reflecting material meant she would not have to wear any underwear. And you made her squat and stretch in these leggings to the point that her pubic hair could be seen. And of course she was lied to, and of course there was no payment for her. In August 2017...
So people need to think about that and think, hold on a minute, how does that make any sense? It doesn't, right? It doesn't make any sense. Basically, it's not how it happened. The photo shoot was 95% legit. 95% of people, it was perfectly fine. They got paid, or they didn't get paid, but they were happy. There was an agreement made. Photos were posted on the website to sell the product. No issues at all. No dodginess at all. That's that. That's where the story.
She was asked to jump about in an unsupported sports bra based on a lie. She was asked to model leggings which were thin and see-through and invited to conduct the wedgie test. And of course she was invited to massage her bottom with a toy. It never penetrated, but that was what she agreed to do and was filmed doing. And of course she was asked to lie on the changing room floor with a thong on her back with her legs spread. And she consented to this because she believed she was assisting you with your research. And of course she never got the money, and indeed was told that there would be no money unless she met you again. Now of course back in 2016, the police spoke to you because they had reported...
So you ask yourself, well, where's the crime? You ask yourself, or you tell yourself, okay, I personally wouldn't do that, but we know people use websites like that. We're very sure that people do these things in person. You know, hey, do you want 300 quid for doing a photo shoot in wearing this? We know people do that kind of thing. Why did I get arrested? Why was there a crime involved? Why were the police involved? There was no crime at first. The police actually arrested me at the time for something completely unrelated. I remember riding around on my bike at night, and I had a bag on my back. In fact, it was actually very similar to that. It was quite a small little bag. And I forget why I was riding around in the night at that time, but I remember riding around in the Wembley area. I used to live near Wembley, and I remember thinking in my head, there was a police car, right, and it kind of like followed my bike a little bit, and I remember thinking, they're going to be suspicious of me because I've got a bag on my back and I'm riding around at night on my bike, and it looked like I was like looking to steal something. I don't know. I genuinely wasn't. Just riding around at night. Sometimes now I go for a walk at night or a drive at night. It's what I do to relax sometimes. Back then, it was a bike. The police stopped me. What are you doing? What's in the bag? They did all, I don't know if they ever searched me, but they took my details anyway. And then that night, at like 1 in the morning, guess what? Get a knock at the door, and there's like 8 policemen at my door. They come in, they search my house, and they arrest me for going equipped, right? And I was like, well, based on what? And they said, oh, well, you had a bag on you, the bag was empty, and you were riding around up and down the road late at night with you didn't give us a good reason. Obviously that's bullshit, right? But we know now that the police do that a lot, right? They do. So I got arrested for that. And so basically the police searched my phone. They went through my phone. It had no password on it. Back then, I was an idiot. I didn't have a password or a pattern on it. It was open. They went through it and they found these messages to different people. And they worked out that I was selling, you call it like attire stuff, clothing, right? They worked out I was selling that. They worked out I worked in gyms, so you could pick all that from the phone. And they also went through the messages and found out that there were people who were agreeing to do these photo shoots, and they linked it to the clothing, right? So then they arrested me at a later date for fraud. And I was confused at the time. I was like, what have I possibly done that would be fraud? When they read it out at the station and interview and all that, I was at first shocked, and I thought, this is ridiculous, because it was genuinely legitimate, and the people where it wasn't like legit people, what happened, to put them on the spot, and the police were obviously trying to create a fraud case here, right? Well, in fact, they were trying to create more than that, but we'll get to that. They were trying to create a fraud case. So these people, they were told, look, we feel like this man has deceived people, we feel like he's done it purely for this reason, he hasn't paid anybody, which obviously I had, but they didn't say that. So I feel like the police pressured these people, a lot of them, and worded it in a way like they were trying to say, look, we want to nail him for fraud, we know what he's up to, we don't like it, and we all know the police do that. We all know, we've seen it happen online, or a lot of you watching will have had it happen to yourself, denied any wrongdoing in the interview in the police station. I explained the legitimate purpose side of things, what I'd done. They asked me about certain people with that, and I said, yeah, they did this, it was legitimate, they were paid, or they weren't paid but we'd agreed to be paid, or we'd give them some free personal training, or whatever it was, right? And that person was happy, there was no issue. I was on remand for this, and the solicitor was shocked. I didn't get bail at the police station, didn't get bail at court, and the case at that time was nothing, there was no case. It was a very, very flimsy case, and they hadn't even provided me with half of the messages to prove my side. The side I gave no comment on that part in the police station because of the way they twisted it, but they only showed snippets of my messages. So we requested at court, we need the full disclosure of the full phone download, proving everything basically, right? That was not provided. I was on remand for 9 months for that case. And the reason I was on remand for 9 months is because I pleaded not guilty to everything for the 9 months, because the police were not providing the disclosure that lawfully they had to. They had to provide full disclosure of all evidence and all data and materials for the hearings, so that we could look at it and decide what to do, whether we plead guilty to that, or whatever. And I will add that I had very, very, very poor lawyer. It was legal aid, you can't pick and choose, but looking back, is the age of consent of 16. However, if that person lies to you, or whatever, if they look older and you've got a reasonable belief they're older and they've even lied to you, that's a defence in court. That is a defence against that offence. However, the age of the photo kind of thing, that is not a defence. In law, it goes by date of birth and nothing else. It doesn't matter what you've been told. So that person could essentially lie to you. It doesn't matter. You're supposed to check their ID or something. That's how it works, right? So that offence is what most people are going to be reading and going, oh my God, he's a wrong-un.
Amongst other remarks at this point, the judge observed that Curtis Arnold had effectively humiliated a 17-year-old girl, a girl you knew to be 17. I just thought I would reiterate that point. The judge then said that...
But I feel it's unfair to label somebody that when the circumstances, which is what I've explained, are just quite frankly not like that, and it should never have been charged, or it should never have been convicted. right? And we're going to come on to the convict.
Nonce.
You know, if you say that to somebody, it has to be true.
I didn't say it to you, I just said it out loud.
Otherwise, it's slander.
I just said it out loud.
And that is an offence.
I just said
just
it
so you
out
know.
loud.
If you keep doing it, I will get you arrested.
So you know, I just said it out loud.
I will get you arrested.
So you know,
I will get you arrested if you carry on. I'm just warning you.
I don't doubt you.
Most police are very interested in why you're actually in this area, okay? And we've reminded us that they've got sexual harm with them. Yeah. They've got sexual harm with them. Yeah.
Nonce.